And I'd like to welcome all members who are participating in person or who are participating by video conferencing. Can I remind members about the protocols regarding the use of electronic devices? We don't have any apologies. Are members aware of any apologies today? No. Okay, thank you. So members, we're moving then to the Organ and Tissue Donation Deemed Consent Bill. The first item is the committee's formal clause-by-clause consideration of the Organ and Tissue Donation Deemed Consent Bill. A copy of the bill and the explanatory financial memorandum can be found at tab 2 of your pack. Do members wish to declare an interest? No, I think I will just declare the fact that I had met at an early stage with the Martin McGann and Dahi McGann's family, just in terms of their activism around this. I'll declare that as an interest. Any other interested members wish to declare? No, thank you. Members, then, I proceed through the clauses and I'll put each of the questions formally. If there is not consensus on the questions, I will ask members to vote through a show of hands, and the clerk will confirm the result of each vote. So clause 1 is appropriate consent to adult transplant activities. And the question is the committee content with clause 1 as drafted?
Agree.
Thank you. Clerk, can you confirm the result?
Yep.
Yeah. Okay. Do we know who that is? Colin. So Colin, yes. Sorry, you're okay, Colin. Do you want to come in there?
I was scrolling into the room.
Yeah.
Get off now.
Okay. So Colin, we're just moving through the clause by clause consent on the organ donation bill. We're on the second clause. So moving on then to clause 2, which is the short title and commencement. So the question is the committee content with the proposed amendment?
Sorry, Chair, that should be the proposed clause.
Proposed clause, yeah.
Sorry.
So I'll repeat that. Is the committee content with the proposed clause?
Agree.
Committee is content. And so the committee is content with clause 2 as drafted. I can confirm that. And I will just for the record confirm that the committee is content with clause 1 as drafted. Yeah. Moving on to clause 3. So clause 3 is the long title.
Long title, yeah.
Yeah. So the long title, clause 3 is just the long title. So the question simply is the committee content with the long title of the bill?
Agree.
Yeah, members content. So therefore, members, I can officially state that the committee is content with the long title as drafted. So members, that completes our formal clause-by-clause consideration. The committee's draft report will be forwarded to members for consideration. And I want to thank members for all the work they've done on that bill, and to thank the committee staff and everyone who has provided evidence to us in this important area of legislation. So moving on, members, then to our item, which is item 4 on our agenda today, and it's Abortion Services Safe Access Zones Bill, evidence from the Human Rights Commission. This is the first of our evidence sessions on this bill, members, and I refer you to your papers at tab 3 of the pack, which include a submission from the Human Rights Commission at tab 3.1 and a copy of the bill and EFM at tabs 3.2 and 3.3. I would now like to welcome by Starleaf Miss Alison Kilpatrick, who is the Chief Commissioner of the Human Rights Commission. You're very welcome, Commissioner. Can you hear me okay? So I can hear you. Yeah, and we're hearing you there as well, Chief Commissioner, so thank you for that. And we are also being joined, I think, by Ms Sarah Sims, who is Policy and Research Officer with the Human Rights Commission. Can you hear us okay, Sarah?
She's not online yet, Chair. We'll bring her up once she joins.
Okay, so Sarah's not online yet, Alison, so maybe I'll go back to yourself and ask you to brief the committee, and then committee can engage with questions, and appreciate you being here this afternoon. So please go ahead, and we would love to hear what you have to say on this bill. Thank you. So we've lost your sound there, Alison. We're just not able to hear you there when you went.
Can you hear me?
Yes.
You can hear me again?
Yep, that's you. That's you now. Thank you.
I was just saying thank you for the welcome, and thank you very much for the invitation. Very much appreciate the Commission being invited to give evidence to you today on this bill. As you say, I will be joined by Sarah Sims. She has done a lot of work on the specific clauses, and she's here to assist as and when necessary. We have made a detailed written submission, so I thought I would save time now and make only a few brief, but accommodate your questions, and you can direct me as to what would you like me to consider particularly. But as a general point, we see this bill as a genuine balanced attempt to redress the breach identified by the UN CEDAW Committee in its 2018 report. And I know this committee is aware of that report and what CEDAW Committee is. It's a specialist group made up of independent women's rights experts from across the territory of the United Nations. The report followed an inquiry which took account of written submissions, evidence, but also the experience of the committee members who visited Northern Ireland. They recommended that the NI executive, and I quote, protect women from harassment by pro-life protesters by investigating complaints and prosecuting and punishing perpetrators. And from the outset, I should make it clear that the Commission has itself considered the human rights consequences of this bill, and the evidence I give today would be the same whether or not CEDAW had made that recommendation. I also want to make clear that today is not about the right to abortion. The law already provides for abortion in Northern Ireland today, and the evidence I give to you today is about the rights of women and girls to access that health care without intimidation or harassment, while balancing the rights of those to express their disagreement. I also suggest that in some cases this isn't even really about the right to protest. I've spoken with a number of people who have attended outside services, and they disavow the argument that they're protesting. They say they're absolutely not protesting outside services, rather they're offering guidance and support. And that does affect the consideration of the right to protest. There is no right, you will be aware, to deliver counselling, support or advice if that is not requested. This bill, with close consideration given to the practical points we make in our submission, should ensure an appropriate balance is struck in line with court's jurisprudence. And in relation to court's jurisprudence, I'm referring in particular to the case brought against Ealing Council. That's probably certainly the most recent fulsome consideration of all of the issues. And that set out the relevant factors in the context of safe zones imposed outside the clinic in London. It drew on domestic and human rights standards, and the Court of Appeal in that case couldn't have been stronger in rejecting the challenge to the designation of a zone. In fact, the Supreme Court rejected an application to appeal because it decided there was no arguable point of law at all. So essentially the test is whether the measures imposed, which restrict and absolutely accept important rights, the measures restrict the rights contained in Articles 9, 10, 11 of the European Convention of Human Rights, essentially the right to manifest religion, to express opinion and to assemble. And just to make clear, there isn't a right to protest in and of itself. The combination of those three rights is what gives people the right not to be moved on if protesting. All measures must be necessary and proportionate. They must take account of all of the circumstances, but they have to look at protecting the Article 8 rights of women and girls to access services safely, with dignity and privacy. And in that context, when looking at balance, it's relevant to note that the decision of a woman whether or not to have an abortion is an intensely personal and sensitive matter, which falls clearly, the courts have said, within Article 8, which goes to the women's physical and psychological integrity. And Lady Hale said, in relation to the NI case brought by the Commission, for many women, becoming pregnant is an expression of their autonomy, the fulfilment of a deep felt desire, but for those who become pregnant or who are obliged to carry a pregnancy to term against their will, there can be fewer greater invasions of autonomy and bodily integrity. So while I say this isn't about the right to abortion, the impact on women and girls accessing the services, it is relevant to take account of the deep-rooted invasion of their Article 8 rights. In the Ealing case, the Court of Appeal noted the safe zone was necessary and proportionate, and in fact it held that if Ealing had not made the order for a zone, a fair balance would not have been struck. It's important to remember that the zone doesn't prohibit and shouldn't prohibit anyone from exercising conscience, manifesting religion, expressing opinion or assembling, but it does and should only place reasonable restrictions on the place and manner of speech within certain zones. The law will be in this bill restricted to certain places. No restriction is placed on demonstrating outside, for example, government buildings or indeed any premises where those making decisions may see the demonstration, and the Commission would welcome that. We say that is a proper balance. neither is there any restriction on campaigning against abortion or abortion clinics. That is also a person's right to do. There isn't even a restriction on demonstrating near clinics or raising awareness of the issue. When considering this bill, I would encourage you to keep in mind that what is restricted is the targeting of individual women as they're in the process of receiving health services. And that goes back to what I said about the Article 8 rights. I also say that the bill applies to all demonstrators regardless of their viewpoint. So once again, it does balance, in our view, the rights of the various rights at issue. Now, I haven't dealt with specifics, but if I could just highlight one before we move on to questions, and that's the importance of determining the immediate vicinity. And I think much of what is said about this bill in relation to the competing rights will be determined in relation to how this is defined. It must be carefully considered in each case to ensure that the Article 8 rights of patients and staff are protected, while also ensuring that any limits on the Article 9, 10, 11 rights to protest are restricted, limited proportionately. And the immediate vicinity definition should include, because the geography changes, multi-purpose sites and take account of the layout of health and social care estates. So each case really should be looked at on its own merits. And finally, we welcome particularly Clause 9, and we see this as a good precedent for other bills because it requires a human rights assessment to be made expressly, and that balances the rights of those receiving health services and those wishing to object to the provision of the services. There is an obligation on the department to consider the effectiveness of the zones and then report annually, and we think this is an important measure to ensure transparency and oversight. We believe the appropriate balance has therefore been struck in this bill, subject to minor considerations and clarity and guidance, as we've set out in our written submission. But perhaps having raced through that rather quickly to allow questions, I can go straight to questions. And I know Sarah is happy for me just to make the statement, and she will come in when I get things wrong in answer to your questions.
Okay, thank you, Alison. And Sarah, I see you've now joined us there, so you're very welcome. Just let me check your sound, Sarah, before maybe we start. Can you hear us okay?
Yes, I can hear you okay. Can you hear me okay?
Yep, we're hearing you fine, Sarah. Thank you.
Great, thank you.
Okay, so listen, a few from myself and then I'll go to members. So I suppose firstly, what does the Human Rights Committee consider as forms of harassment that should be covered by this bill? Where does the line between harassment and people saying they're protesting or whatever, in your opinion, Alison or Sarah?
Yes, perhaps if I can, what I don't want to do is get into a list of things that will or won't be. It is going to be context dependent, and it is going to be, some of it is going to turn on the environment within which these actions are carried out or discussions are had. But I think what a reasonable person would consider to be an interference or to be an attempt to put pressure on somebody or to humiliate or degrade somebody or indeed to invade their privacy. And that's why we talk about how there should be a prohibition on taking images, photographic stills and recordings of people. It is an intensely private personal experience having to attend for that sort of healthcare provision, and there is no justification for capturing images of a person attending for the service, albeit there is a justification for expressing your view that the service should not be there in the first place. There will be a threshold, and it is the most helpful thing I can say, I think, is that it is a threshold of reasonableness and what a reasonable person would consider. And I must recognise that some of that will be determined by courts. I suspect this is going to go through the court process, and we'll get some further guidance. But I don't know whether Sarah, who has spoken to more stakeholders than I have recently, whether wants to add anything.
No, not at this moment. I think you've covered that okay.
Okay, thank you, Sarah. So the second one for me then is around the consultation process, and what, in your view, would be what consultation should the department undertake in relation to specific safe zones?
Yes, I think we were overlapping temporarily. In relation to specific safe zones, it will depend again on the geography. In some cases, it will be necessary to consult with residents, with local businesses, certainly with the service providers, and possibly with patients or potential patients. In some cases, it may be much more straightforward. I think the department needs to be satisfied itself, and it needs to receive as much information as it considers necessary to make a rational decision. Certainly, anyone who wishes to consult with the department, I think the Commission would say the department would be well advised to listen, but it has to draw a line.
Yep, okay. Thank you. And the final one for me then is that around the time limit that you have mentioned in your presentation, and you say that those should be limited to a specific time limited period with review built in. So what sort of time period would you suggest, Alison, or is that specific, case specific, or what you're thinking on that?
I think it's case specific. I think each case needs to be considered. If you go back to the justification being necessary and proportionate, time will also be a factor in relation to that. It may be that some will only require a short period of time and should be renewed and withdrawn if there isn't a reason to carry them on. Others, there may be more focused protest, which is interfering with people's right to access the premises over a longer period of time. But I think if it's kept flexible, so an anticipation that it should be reviewed certainly within a matter of months, I think that would meet the necessity and proportionality.
Okay, thank you. So I'm going to go to members then. So Paula.
Thank you, Chair, and thank you very much for coming to committee today. I suppose my first question is in relation to case law around such protests, and I'm just wondering, is there, do we find this in any other branch of healthcare where people are trying to access healthcare for personal reasons? And also in terms of the balance you talked about, how can it ever be justified that somebody would try to be intimidated out of accessing healthcare? How can it ever be justified that other people could engage in that?
To answer your first question, has it happened in any other branch of healthcare? Not that I am aware of, and I have looked. Certainly not on these islands. The only example I can think of, which was one part of America, was where a group of Jehovah's Witnesses tried to block certain parents taking children to access just ordinary GP, what we would call GP appointments. That's the only time in which it happened. There was no difficulty whatsoever in the States with their constitutional right to protest engaged in that case, and the court said it was perfectly appropriate to have an injunction. And you'll be aware that in the United States, their constitutional right to free speech is guarded very jealously above almost all else. And the second point you make is a very valid point. It is very difficult to see how, on the one hand, if you're dealing with somebody's right to attend for health services, and it has to be seen as health services, and I think that puts the consideration into its proper context. To be able to do that privately, to be able to do it with dignity, and to be able simply to access the service without fear of recrimination, that is always going to weigh very heavily in the balance against somebody's right to say that the service itself should not be provided. So while you have a right to protest and demonstrate against the provision of services generally, what you don't have is a right to intimidate an individual. And as I say, going back to the evidence that the CDAW committee found and that has been put forward in relation to a lot of inquiries, is that the targeting is on individual women to try and deter them from accessing a service. It would be very difficult to see how there is a right to do that firstly, but even if it was a right to demonstrate to an individual person their objection to the provision of a service, it's very difficult to see how it would be justified to do that when somebody is actually in the process of receiving the service. So I think in almost all cases, the right of women to access the service would weigh more heavily in the balance. And it's hard to see how a woman would be required to attend a service while pushing her way past either physically or psychologically barriers to her achieving the service.
It might be a bit of a left field question here, this last one, Chair. When I spoke, for example, to Belfast Trust last week, and they were talking about how it can sometimes take up to 15 minutes to calm women down, you know, who've gone through the traumatic experience of pushing their way through a protest. Is there any recourse in law for the trauma that's caused to those women when they're accessing their service?
There's actually very little, and that's one of the problems that this bill, I think, will try to overcome. Firstly, I would say to you, it's probably too late after the event to consider using any sort of legal redress. A woman in that situation isn't thinking about her potential to sue, even if she really did have one. You will be aware that the Protection from Harassment Order requires a course of conduct, and most people will be visiting on one occasion, or certainly will be confronted by different people on different occasions, so that legislation doesn't help. This is to enable them to access their healthcare without having to be in a state of emotional distress and be calmed down by doctors. And there really is no substitute for that. Even if there was, as I say, a right to sue somebody, it would be difficult to know who. The provider of the service has some duty of care to their patients, but it's very difficult for them because we're talking about public space. So the provider of the service would have very limited options as to what they could do. This is a bill which is about public spaces, so it would be for the department really to take control of this issue.
Okay, thank you, Chair.
Thank you. So I have then Jerry indicating in the room, and on screen I have Carol and then Colin. So I'll go to you, Jerry, first.
Thanks, Chair. Thanks for the presentation. I mean, albeit very limited in specific circumstances, could you confirm that if this bill were to pass, then this would be effectively the only restriction on people who are engaging in anti-choice activism or protest, or however you want to describe it? You know, people can still parade, protest for their opposition to abortion, but they can't do it outside specific healthcare settings. So just if you could confirm that. And the second question, in the briefing you mentioned consideration of images and audio, I think was a direct quote. Obviously we've heard distressing stories of really distressing sounds being played is the only way that I can sort of describe it outside some of these clinics and health settings. Have you considered about shouting as well? Because I think, you know, there could be a situation where something is played on an audio device or a megaphone, or but somebody could be physically close to one of these healthcare settings, and it could be shouting, you know, expletives at a woman. So has that came into consideration? And then the first question. Thanks.
Yes, you're absolutely right. This bill doesn't prevent anyone from protesting about anything, and it certainly doesn't prevent anyone from protesting or campaigning about their opposition to abortion. They can use the media, they can use various other platforms, they can campaign and protest outside decision makers' premises. And in fact, this bill also allows them to protest relatively near to abortion clinics and those providing services and advice. What it doesn't allow is for them to invade the space and upset unnecessarily and disproportionately people wanting to avail of the service. So they have absolutely every right to say they disagree, but they do not have a right to impose that on other people in the process of accessing the service. And I should say, in the Ealing case, which is probably worth going back and having a look at when you're looking at maybe the finer detail of guidance that will follow, the Ealing case looked very closely at balancing these rights, and it was actually a very strict access zone that was imposed in that case, and the court had no difficulty in saying that it was an appropriate balance struck. In relation to images, shouting, etc., we think that the more that is given by way of example as to what is inappropriate is helpful, but not to be too overly prescriptive in legislation, because what you may get then is attempts to simply avoid the very technical letter of the law and not comply with the spirit of the provisions of the access zone. So certainly shouting would fall within it, and images are distressing not just to people availing of the service, but also members of the public and children who are walking by. And the sounds you're talking about have been described to me certainly as some of the most upsetting elements of what happens outside some of these services. So yes, there should be flexibility, to respond to creative ways to continue to intimidate. But it should be made clear in guidance that this is broad and it's judged by the effect it has on the reasonable person availing of the service. Sarah, did you want to add anything in relation to images and, for example, loudspeakers and things like that?
Yes, I was just going to add in relation to the Ealing case as well that it was 100 metres was the vicinity in that case, and that we did reference the use of loudspeakers within our submission as well.
Thank you.
Thank you. So going across then to Carol on the video. Carol, go ahead, please.
Thank you, Chair. Thank you, Alison and Sarah. Sarah, I just want to ask, just for clarification on something you said around the possibility for the need to consult, possibly if it's outside of what's known as a traditional health and social care setting. I just wondered, did I pick that up right? You know, who would you consult with? Because my concern that would be, you know, if it's health and social care, and it is, then, you know, it doesn't happen with any other aspect of health and social care. So if you could just clarify that, please.
Sure, I think that may have been my mistake actually, that I wasn't clear enough. What I meant was that sometimes you will have a service provided within a larger estate, and that needs to be taken into account. So it wouldn't just be a standalone service. That if it will prevent women accessing the service by walking through another part of an estate, then that should also be protected. So it is going to depend very much on the geography and just who is most affected. And obviously, in some cases, residents are going to be affected because there may be residential accommodation very close to the entrance to the hospital or the estate. Does that better answer the...
Yeah, I appreciate what you're saying. It's just that for me, it's just going to single out this aspect of health and social care. I think there's concerns, human rights concerns around that as well. I'm not ignoring any potential impact of any potential protest on residents, so I just want to make that clear. But for example, in my own constituency, our health and wellbeing centres are right in the heart of the community, and I welcome that. Because it means to say people can go and access health and social care almost like a one-stop shop. So particularly, just by way of example, if they're going for, you know, psychological or emotional support, then they're going through the same door as someone who may need chiropody, okay? And I think that, you know, the ambiguous nature of accessing services works out quite well. I think once you alert people, even within that setting, then for me, we're actually undermining our own argument about the ability to access health and social care. And so the emphasis seems to be on the protection of people protesting rather than protection of people who want to access health and social care. So it's just a small concern that I have, and I do agree that the guidance and regulations are going to be key to this. So that's just my own thoughts. Thank you.
No, I absolutely agree. I don't disagree with anything you said, and that is where it gets tricky, because there's a really strong argument as to anonymity of the service for people attending to get the service, and there will be situations exactly as you describe, where the general public shouldn't be consulted and residents shouldn't be consulted, and that's where it does get why we keep going back to a case-by-case basis. So the geography of the actual service, who's using it, who may or may not be affected by it, and whether or not there should be notice to the public that there is in place a safe access zone. I mean, I think all of this can be fleshed out in guidance, but also experience. You know, and it's why I think the access zone should be kept under review for everyone's benefit. And the primary consideration would have to be, given the grave consequences for the Article 8 rights of women and girls, the primary consideration should always be the patients and those and the staff at the service.
Chair, just following on from that. So for example, in theory, clause 4 in health, or even clause 3, you know, where clause 3 and 4 and 5 look at the safe access zone. So at the minute, protected premises because these services will be delivered within that traditional healthcare setting. So in the case that we have outlined where perhaps is outside of that, then could that zone almost include the residents, so that's protected also, and that would need to be done by the Department of Health? Mm-hmm. Okay.
Yeah. Sarah, do you want to? I hope Sarah agrees.
Sorry.
Sarah agrees.
Yes, just again stressing the importance of it on a case by case basis and that consultation with the operator, and the operator will obviously be aware of staff and how staff feel within that health and social care provider as well, and that their rights are equally as important as the patient's.
Okay, Carol?
Yes, Chair. I just wanted to get that clarity. Thank you.
Thank you. Okay, and going to Colin then, and then I will have Pam. Colin, then Alan, then Pam. So Colin, go ahead, please.
Thanks very much, Chair, and thank you, Alison and Sarah, for your presentation. It's really appreciated. I was just going to ask about the recommendations that you have in your paper that you've presented to us. There is reference to the European Court of Human Rights in determining the introduction of the safe access zones and about keeping an eye on their decisions in other cases. Has there been any other precedents for this at the moment, or do you envisage that being something going forward?
There are some precedents across Europe, within the Council of Europe region, but the only one on these islands is the Ealing case. But it did go through to the Court of Appeal, and then there was an attempt to appeal to the Supreme Court, and the Supreme Court said it didn't even raise an issue that required clarity. So they strongly reinforced the argument in the Court of Appeal. So we have very strong authority insofar as it's gone. I am expecting it to go further. In Poland and some of the other European countries, there are cases going through at the minute, and we're going to be keeping an eye on what's said about those.
Okay. Then just the other issue that hasn't been raised at this moment is there is reference to recordings and to photographs. Would you deem live video streaming as a recording? Is that your understanding in terms of the law, or is that something that maybe needs to be fleshed out, whereby people use cameras to do like Facebook Live and other types of broadcasting from a space? Is that covered under the terminology of recordings?
I think, well, whether or not a court would agree with me, I'm not sure. That probably requires a bit more technical expertise. I can barely use my own iPhone. But I think it would, certainly if what you're doing is communicating to somebody who's not there, you're recording them first, albeit it's going out live. And that comes back, I think, again to the point about flexibility. So you have to make it clear the purpose to be achieved, and it's not to deter people from accessing services or to for their experience to be an undignified one, which breaches their privacy and right to confidentiality.
Okay,
so
that's that. Yep.
Examples, without being too prescriptive, you have to allow for different methods developed all the time to get around rules.
Okay, that's grand. Thank you, Chair. Thank you, Alison. Thank you, Sarah.
Thank you, Colin. Alan.
Thanks, Chair. Paula asked earlier if other medical services had ever been subjected to this level of protest, and I appreciate that this example is not even close to the level of protest and harassment that is happening outside abortion service clinics. But recently we have had protests around vaccination. There were young teenagers at a school in Londonderry who were harassed seeking an injection of vaccine for COVID, and also there was minor protests outside vaccination centres in West Belfast recently as well. Excuse me. So I'm just wondering if if you would have an opinion on whether it might be prudent to future-proof this bill by maybe inserting a clause that would embrace and protect access to other medical services other than just abortion, although abortion is a central issue at the moment. And the other thing that I would worry about would be if these people who are so maybe hell-bent on protesting, if they are prevented from protesting within the vicinity of abortion advice centres, is there the potential that they might shift the subject of their and location of their protests to, say, the homes of staff or practitioners? And would the current law sort of protect against that situation, or again, might it be prudent to, and I don't know what the form of words would be, but to introduce some form of words that would also protect practitioners or those working in these centres from having the protest shifting to their private lives and their place of residence? Thank you.
If you don't mind me saying, I don't mean to sound sycophantic, but I think you've sort of hit the nail on the head as to where these decisions become very difficult and nuanced. There is a danger in making a piece of legislation which is for a very specific purpose, where you're balancing the rights of a patient and staff delivering a health service against those who wish to object against the service rather than the people, to make it encompass much more broad situations of receiving health treatment or protest. And I think if you broaden it out too much, you fall into danger of tipping over the balance, perhaps, away from the protection of the Article 8 rights of patients and staff to the protesters. What you say, though, in relation to what happens if the protest is moved, that's a really important point, because that is exactly what might happen. At the minute, the law, the protection from harassment is the most obvious one, perhaps, requires a course of conduct. That could be reconsidered. Antisocial behaviour orders can also be considered in relation to specific cases. And I think it would be easier and probably better to consider the other laws should the targets move from the patients to elsewhere, rather than trying to put it into this bill, which is very specific and very limited.
Thank you.
Thank you, Alan. And going across then on the video to Deputy Chair Pam Cameron. Go ahead, Pam, please.
Thank you, Chair, and thank you to Chief Commissioner and the rest of the panel for your attendance at committee today. My question kind of leads on quite nicely from Alan's, actually. And I just wanted to say from the outset and put on record again that intimidation, harassment and abuse of any kind in any scenario is completely wrong. And I suppose Alan made very interesting points there around where this type of activity or protest could move to other venues or indeed to personal homes, as an example. And I was wanting to ask you, Chief Commissioner, whether this type of activity, as in the legality around intimidation and harassment and abuse, is that not already covered under current harassment laws that are in place? And if that's not the case, then should we not be looking at strengthening what is currently there to ensure that that people are not subjected to this poor behaviour across the board in any circumstance? And I know you've referred to should that protest move on to those other venues, that those other laws should be used or looked at. But surely then, with that same train of thought, surely those laws in general should protect everybody in every circumstance.
Yes, there is a difference, however, and in relation to the laws on harassment, and this would apply in relation to harassment anywhere within Northern Ireland, you do have to come within the statutory criteria. As we said, it wouldn't cover, for example, counselling or offers of support immediately outside a service, an abortion service. That wouldn't be called harassment, but for a woman who is in the process of accessing that service and has not requested consultation or indeed to meet anybody or reveal her identity to anybody at the time, that would be very detrimental to her emotional well-being, and that's the evidence that we have heard. So that may not fall within the legal definition of harassment under the current law, but it is something which would be which comes into play in that very moment when somebody is trying to access a service in those very difficult, sensitive moments. So the two laws don't really they don't substitute for each other, if I can put it that way. The law on harassment away from a service would be different to the law on accessing a service by a woman who is exercising her Article 8 right. I think that probably, to put it short, the short answer is protection from harassment order as drafted or even as amended wouldn't deal with the situation that is under review here. It couldn't be used to enable women to go to an abortion service with dignity and privacy.
Okay, so just for clarity there, Alison, you're saying that the laws couldn't be strengthened in order to deal with this particular scenario?
I'm saying the laws as they are. I don't see how you could amend the current laws to cover precisely this situation, which is people in the process of accessing a health service, being offered consultation, prayer, having things shouted at them. The law as it stands, or even as strengthened, would not apply in that very situation, and it would be reactive rather than protective. I think the key here is that a woman has to be free to access that service, and if she's put off, it's too late. The law doesn't really protect her at all. So this is about protecting somebody before they even have to encounter the potential of taking a suit or proving harassment. So it's prevention rather than cure.
Okay, thank you. Thanks, Chair.
Thanks, Pam. And I suppose, Alison, another one that occurs to me sort of as a result of the conversations and the questions, and I noted that comment and I thought it was very relevant around the recording issue, and I suppose it raises a general concern that any legislation will be scrutinised to the nth degree by those who would seek to find ways to continue harassing women in this situation. Are there any other areas of, and I know we've previously heard from the sponsor of the bill around the issue of harassment being 2 episodes of harassment, and then people then doubling up, if you like, and 2 different individuals conducting the harassment to evade that particular legislation or definition. Are there any other areas within the bill that you'd be concerned around, either in legislation or to suggest for guidance, that would need to be considered in that respect to ensure that people don't successfully circumvent the legislation?
I think it's all going to come down to really careful consideration of what is a designated zone and what is prohibited within the zone. So it's less maybe about the legislation, more about the actual application of it and the decisions that are made on a case-by-case basis and those review of those decisions. And we very much welcome the obligation of the department to publish a report and to review the effectiveness. And I think what is likely to happen is that as time goes on, we'll learn much more about what is and isn't effective, and what can and can't be prevented in a safe zone. And as I say, it really comes back to, I wish I'd put it this way the first time, it's too late after the event because it has actually interfered with the person in the course of getting their health treatment and has interfered with their rights to bodily integrity. And it's too late after that simply to sue and have some sort of damages redress or even an injunction for further use. The damage has been done. So this is all about enabling somebody to access that service at a critical time in their life, not having to deal with it afterwards.
Okay, thank you. And final one from me then is in relation, and I know that you have mentioned the Ealing case, and Sarah has certainly mentioned the Ealing case on 100 metres. Do you think is that an appropriate kind of yardstick in terms of, with everything else being equal, that 100 metres is about right? Or do you think, is there evidence to suggest that that it should be more or less?
I think it just comes back to geography. It comes back to the layout of the site and the layout of the estate generally. In some cases, 100 metres may be too much. In other cases, 100 metres may not be enough. So it'll depend on the access points to the clinics, and it'll depend on whether or not you have to go down, for example, a single access road to then get into a general entrance area. The Ealing case, what it certainly told us is that the individual access zone is what will be considered, not the general principle behind it. So it will look at all those various factors. In Ealing, they had an access zone, but then it was a designated area within it, within which certain protests could be carried out. And that was permissible because of the geography, but not as a general principle. I don't know whether Sarah can give any examples in relation to zones that have been set up now in Manchester in relation to distance.
I don't have a specific example off the top of my head, but I can certainly follow up with the committee on that if required. I was just going to add something just in terms of the previous question. And we did advise that when a safe access zone has been established, that the department works with the operator in terms of establishing guidance for the operator and how they can make it publicly known that the safe access zone is in place to those that say are wanting to protest around the area, that it is clear that it is there and what the requirements are.
Okay. Thank you. I'm just going to take a quick check if there's any other members, or indeed if any members want to ask an additional question. There's a little bit of time allowed, but I don't see any further indications at this point. Paula, go ahead.
Sorry, Chair, I didn't want to take up too much time earlier. It was to do with the reporting that they've mentioned in terms of recommendations, and put the onus on the department to report annually. And I'm just wondering, who else has a role really in that? Is it the trusts, or is it the PSNI? You know, where else could we? I'm not wanting to put additional burdens on already stretched services, but I just wondered, is the department the right vehicle to collect and collate that information?
Yeah, it's hard to think of who else would be in a better position, but it's going to be dependent on the department consulting properly, and that would be with, for example, the PSNI, with the operators, with patients if possible, with residents, etc., and with people who have attempted to protest. So we would hope that the annual report would consider all of those various aspects, but also in relation to enforcement action that's had to be taken during the period of time, and whether or not the zone has been effective at all. So we would hope all of that would be covered in the annual report.
Thank you. And just one other question, and it's in relation to the outstanding issue we have here in the Northern Ireland Assembly, and it's around the introduction of safe staffing legislation, and it's primarily around optimal levels of staffing within the settings. But I'm just wondering around the safety of staff travelling to and from and through these protests, and I'm just wondering, is there anything that this bill could do to strengthen the protections for staff who not only are having to travel through it, but also comfort those women when they arrive?
Yes, and I think if, again, going back to the point about it's too late after the event, the damage has already been done. These safe access zones have got to apply to also protect staff travelling to and from the centre, or in fact coming out to meet women and girls who are accessing services. So the idea is that they wouldn't have to deal with that harassment at all when accessing their place of employment or helping their patients. In relation to travelling to and from, that becomes more difficult, because that would be essentially requiring an access route, almost a free route, by which they could travel from their home to their work, which wouldn't be enforceable. But the other laws on harassment, also assault, etc., PSNI should be consulted, I think, along with the trusts, as to what is happening and what law is already in place that they can do to actually assist those staff members.
Okay, thank you. Thank you, Chair.
Okay, thank you very much. And I want to thank you, Chief Commissioner, and Sarah, for coming to committee today. for providing your presentation to us in advance, and also for your remarks and your addressing of questions from members today. And I want to just wish you all the very best in the time ahead, and sincerely thank you for attending.
Thank you very much, Chair.
Okay.
Perhaps I will follow up with these specific questions. Thank you.
Okay, thank you.
Thank you.
Alison?
Bye.
Yeah, bye. Okay, members, thank you. And that just leaves the issue of next meeting to be addressed. And our next meeting will be on Thursday, 9th of December, via Starleaf. Thank you, members.
Room 30. This is the Northern Ireland